Hi, everyone. Last class, huh? Hell yeah. Feelings mutual. No. Soak in the moment, guys. The law school goes so fast. Before you know it, you'll be studying to the bar. You know, my very first ConLaw class, first time I taught ConLaw, those students are now graduating. And now they're getting ready for the bar, and you'll be there before you know it. I appreciate that Katie brought me some cookies. Unfortunately, it's Passover, and I can't eat them. So, but it was very sweet gesture. I appreciate that. Thank you very much. Not the first time it's happened either. It seems always that people give me free food at the end of this mess when I can't eat it. I will endure. I have some matzah in my room if anyone wants any. It's not very good, but all I can eat this week. Okay. Questions? Anything in your mind? Anything bothering you? What? What's funny?
Everything's bothering me.
Oh no, you guys have to relax. It's not. You'll be fine. However hard this is, it gets much harder after you graduate. It's true. At least here we have a structure. I take property on this day, I take ConLaw on this day, I take contracts on this day. After you graduate, you're on your own. And you have to decide for yourself what you're going to do and how you're going to make a living. And there's no schedule, there's no structure. So as difficult as this is, it gets a lot more real in about 2 years or so. So enjoy the moment, if you will. I know before on May 9th, we'll have a review session. Please come to that. If you don't, well, that's your problem. But that's your real last chance to ask questions and get things resolved that you understand. I found in the past that attendance of these is strikingly low. I can never figure out why, but this is for your benefit, not mine. Any questions on freedom of speech? Any questions on the First Amendment speech clause? I realize I crammed an awful lot into 4 hours, not nearly enough time to cover the material. Any questions on that? Okay. So today, in my remaining hour and 56 minutes with you, we will cover the First Amendment religion clauses, and primarily and almost really exclusively the free exercise clause. I don't have time for much in the establishment clause. Well, maybe I'll mention it briefly at the end. All right, where did I finish last time? Are you up first? All right. Why is religion special? I'm asking you.
I don't think it's special.
Okay. Why not?
I think it's for certain people.
I'm sorry. Say it louder. I didn't hear what you said.
Did it when it was, I guess, when the Constitution at this time, it was important for them to, I guess, put a limit on the federal government
Uh-huh.
to prevent them from either establishing or, I guess, setting like I guess an established church or something in the state or.
Okay. Okay. Colby, why do you think religion is special? So special that it warrants an inclusion in the First Amendment with the right of free exercise. Why? What about religion makes it special? And if you don't agree with that statement, maybe as your colleague did, perhaps why did the framers of the Constitution so think?
I mean, it's a vast amount of people that adhere to religion, follow religions, and it's also like kind of a guiding principle for a lot of people. So it changes the way people think, the way people act. They adhere to something, or they can not act one way, or they can act one way just because of their religion.
All right, Scotty, you're about to jump out of your chair.
Yeah, it's.
I usually don't go to the roster, but I'll give you a slap the last
Thank
class.
you, I appreciate it. We were a nation founded on religious liberty. We had the Quakers settling Pennsylvania. We had the Catholics in Maryland. We had Puritans in Massachusetts. We were founded by all these different religious sects who all came here to practice without being inhibited. I mean, we had the Huguenots in France. We had so many different religious groups in the founding of this country, and they were seeking to preserve the very reason they came here.
Okay, well that's absolutely true. It's absolutely true that a lot of people practice religion. I think you made the same point, but my question is actually a different one. Why do we protect religion, right? It's certainly true, right, that groups came for these purposes. But Elizabeth, why does religion warrant a special place in our system of laws? And moving more to discussion today, why is it that religious beliefs are given more protection than perhaps other types of beliefs which are not religious in nature? Okay, and maybe I'll go to my friend Dylan over there, perhaps who's not religious, atheist, agnostic, or
I
don't know. Okay, so why are I know I'm making this personal, but why would an atheist's beliefs be any less worthy of protection than someone who calls it Christianity or Judaism or Islam or whatever else?
So,
What about this idea of religion that elevates a belief system to a plane that warrants protections that perhaps other beliefs do not?
So atheism is not a religion? I mean, it's
It's a system of beliefs. It's a system of beliefs. Why is that not warranting of the same sort of protections? Yeah? What do you think?
I mean, it's still a set of beliefs. And I mean, I guess when people believe in something, it kind of guides their morals and who they are. Like it it's part of their identity a little bit.
Standing person without believing in a God or a creator. I mean, I would never pass judgment on someone who didn't believe in God. They can be a good person, be kind to others. They can in fact be more, kind than a person of faith. But why does our Constitution privilege and single out the exercise of religion? What about religion, and this guy's points well taken historically, but what about religion warrants this sort of special protections?
I mean, religion inherently focuses on almost the laws of nature, the laws of man.
What do you mean? Give us more.
I mean,
Explain yourself.
if you look at the Bible, for instance, I mean, you find all these codes that you're supposed to abide by as a person. But those codes are more morality based, and they're more subjective to the individual, I guess. Where I don't know, laws of man are more objective, general to society as a code of what every person should and should not do.
Tariq, want to take a stab?
I think it's a fundamental right.
Fundamental right. What does this word fundamental mean? And don't tell me what the Supreme Court said.
Not the Supreme Court, but it's one of the rights that deserve certain special kind of protection. But the implications of not protecting them are going to be severe in society. So you have to give them.
But why is religion special? Why can't we protect other beliefs which are not called religion? Right. Okay. So I'm glad we're having this discussion. I'll get you a second, Martha. I'm hearing a lot of things repeat that core and fundamental and inherent. But I'm trying to drill on this question, which maybe doesn't have an answer, but I want to discuss it anyway. This: why does religion get special treatment? And let's just use the example today. I'll get to you guys in a second. Let me pose a question. We have this case today, this Smith case. We'll do in a few minutes. And here you have a Native American, right? It's a part of his religious sacrament is that he wants to use peyote. Okay, we'll get to the facts in a second. The case was 5-4, right? It came out awfully close, right? 5-4. Could come out the other way. But what if instead of having a Native American who wanted to ingest peyote, you had a stoner who said, you know what? I like shrooms. Shrooms make me happy. They make me feel good about myself. I don't care that these shrooms are shrooms are short for mushroom. Those of you who have good consciences, right? You say, I like shrooms because they make me feel good, right? They make me a better person. Now, I think if I polled the people in this room, there'd be a pretty good debate about whether the controlled substance law should be relaxed for Mr. Smith, the Native American with the peyote, right? But if I, well, maybe not in this room, but if I poll the American people at large, should some stoner be allowed to trip on shrooms because he likes them? The debate would not be nearly as close. So my question then is, why do we even entertain religion as a reason why we should excuse people from the laws? Whereas if it's just, I like shrooms, I like tripping, right? I like hallucinating. That's not something which this room perhaps accepted, maybe society at large would tolerate. Mirza, your hand was up a minute ago.
Oh, religion is special treatment because highlights obligations to our creator. Creator maintains. So there are certain obligations we have to the government, and there are certain obligations the government has to us, but people individually have an obligation to the creator, and they express that through religion.
Good. John, your hand was up a minute ago.
Sorry.
You gonna pass?
Yeah.
Okay, Samuel.
For different jurisdictions, this is the United States. That's have two different things.
So there's like ultra virus. It's like like subject matter jurisdiction.
I think Pope said something when Michelangelo painted one of his guys on the devil's face. And the guy came like, "Hey, you got to make him change it. It's awfully big." And he said, "Pope said I don't have jurisdiction there."
You guys aren't answering my questions though. Dan, I appreciate. Yeah, okay, John, you get to redeem yourself, literally and spiritually.
So initially, I was thinking of Burwell Kennedy's decision when we talked about
Okay.
Kennedy's rights.
About dignity, yes. Okay.
So that could be, protecting dignity is something that, I think that's been said around is that, it's something unique about people that sort of protection. It's something different than other systems of belief that, might be special. So the intimate relationship, a little bit with the obligation, but it's a relationship between yourself and something beyond, something that's, deserved, has is unique. And the other part I was going to say is maybe like autonomy, the ability to allow us to, decide on our own what we like to believe. So I think that in that sense, if we want to express ourselves fully, we should be allowed to do that. It's really.
But okay, so I ask my question again. Mr. Smith with the peyote, right? I think it's a pretty vigorous debate whether you should or should not allowed to use it because of religious purposes, right? Stoner on shrooms, right? I don't think we get nearly as much of a defense. Why do we privilege Mr. Smith using the peyote for his religious experience over some random stoner who wants to because he feels good? Why?
Is it because peyote shrooms are legal?
They're both illegal, but why would there be a good debate about whether Mr. Smith should be excused, but not the random stoner?
Is it because his beliefs are more genuine?
What do you mean genuine? Are we questioning a person's release? A stoner believes firmly in shrooms. This is his existence, right? He's a stoner. That's what he does.
So this kind of goes back to the means in the end. So one is seen it as okay, this is fundamental, it is fundamental. Whereas the other one's hey, maybe I can just find a way around the law to.
Who are we to judge? I'm speaking, right? Who are we to judge that the Native American with his belief system, and he was a convert, by the way, so not a convert, but he came to it later in life, any more genuine than a stoner who's when I go on a trip, I see amazing things. I get connected with the universe. Not religious, it's narcotic, right? But who are we to judge? And I'm asking this question sincerely because this debate summarizes very concisely the entire class. Dan, you were next online, and Natalie, next.
Well, to an extent, I think it's a little bit structural.
Structural, okay.
First of all, establishment of societies was first based on the belief in the supernatural,
God.
whatever that may be.
Okay.
Let's be fair to everybody. So, as our nation was being put together, it understood the disconnect or the power struggle between that power exercised over people by religion and the power exercised over people by annihilation, new laws, and everything like that. So it's very hard to just completely break away and say one's wrong, one isn't.
So you're giving Scotty a historical answer. You think that the answer why we protect religion is just as a vestige of history?
I'm getting to it.
Okay. I'm sorry, I'll let you finish.
So it's hard to eliminate one aspect of it, so inherent to people's existence.
Okay. I'm sorry, keep going.
So as a system,
I thought you were finished.
I'm going too far.
No, keep going, keep going.
So,
Whatever you
as
want.
a system or a new government is being put in place, it's important to acknowledge those rights, those beliefs, how people participate in communities with regard to that.
So it's a tradition that we're protecting.
Yes.
Okay. Okay. Natalie, patient waiting.
Well, I want to see that founding fathers viewed it as part of like the inalienable right of life, liberty, and happiness, and like that. I mean, sort of touching on what Terry and Travis said, that it's sort of like a natural, fundamental right.
Okay.
Someone can be.
Okay. So all these things are true, right? So I've heard a lot of things. I'll try to synthesize these good answers. Very good discussion, right? So we have, as a matter of history, our nation was indeed founded on people fleeing from religious persecution. You had the Quakers, you had the Calvinists, you had the Pilgrims, you had the Catholics, you had all these different groups settling in different parts of the country who were attempting to flee various forms of religious persecution. That's definitely there. And a couple of you guys said tradition, right? I mean, you have a long-standing tradition in America of religiosity, that people have faith. And then it makes sense as a matter of tradition to uphold those institutions which have been around for millennia, right? Organized religion, I'm celebrating Passover today. This is a holiday that dates back thousands of years, right? Jesus' Last Supper was having a Passover Seder, for Christ's sake, right? No, sorry, that was bad. Right. We have a long tradition in this country of faith. Okay, but none of you are answering the question. Okay, second, Natalie. But none of you are answering the question I'm asking. Why today, in 2016, as we're sitting here right now, should we treat any differently the Native American who wants to use peyote from the stoner who wants to trip on shrooms? Right? You can give me the Constitution. That's a good answer. And personally, I would accept it. But I want you to put that aside for now. Assuming we're writing a new charter, right? A new constitution, a new statute, whatever you want to say it. Why do we privilege spirituality, we call religion, Native American, whatever it is, as opposed to a stone or tripping on shrooms? Whoa. Okay, you were next up, so I'll give you the line, but then I'll move around.
I would say we shouldn't.
We shouldn't? Okay, tell me why.
On a fundamental level, I don't see any difference between choosing to use drugs and believing in a religion. I mean, they're both, from a governmental standpoint, unless you can show an interest in why an individual shouldn't be able to use drugs or why an individual shouldn't be able to believe what they want, I don't see any difference. They're both choices.
Now let me flip your answer around. You said a governmental interest, right? Could it be that there's a governmental interest in having religion, but not a governmental interest in people tripping on shrooms?
I would say no. There's a governmental interest in them not tripping on shrooms while driving down the road.
Well, granted. But perhaps, and I think you're inching to the thing I was looking for, indirectly perhaps one of the reasons why religion is protected is because it affords certain benefits to society. Oh, who else? I saw a spade of hands go up. Yeah.
Oh, I have a question.
Okay.
I can see how governmental interest would exist for a state government since they have moral policing powers, and a lot of the morals are derived from religion.
Mm-hmm.
However, for a governmental interest, I mean, like just the federal government, where would an interest be?
Let's just talk about the states. I don't care about the feds here. They don't have enumerated powers here. Let's talk about the state governments here, right? So let me restate Taylor's point a little bit differently, right? Maybe one of the reasons why religion has persisted in this sort of privileged special place for hundreds of years is because of some of the benefits society attributes to religion as opposed to a dude tripping on shrooms. And I'll give you a couple examples. All of you hopefully will be charitable one day. If you make a donation to a religious organization, that's a charitable deduction. You can write that off your taxes. Once you're making income, you can actually do these sorts of things. You're all negative net worth right now, as am I. But assuming society says we want people contributing to religion. Many governments provide funding for religious schools in different respects, notwithstanding the Establishment Clause. If you're a student at a religious school and you can't afford lunch, governments provide affordable lunches at religious schools. They provide subsidized foods. If you're a member of the clergy, you don't have to pay income taxes the same way other people do. Even if you're a church, you don't have to file a tax return because it's assumed that we don't want you burdening yourself with this. Right? So the question is, what are the sorts of benefits that perhaps society has attributed to religion? And maybe you don't agree with them. Maybe you think they're wrong, right? But why are these perhaps society recognizing? Is your hand up?
I think religion provides like a stronger sense of morals and values than you can find elsewhere, because philosophy doesn't really provide a strong. And this is some of the criticism that goes into philosophical justifications for morality and systems of ethics, is that it doesn't necessarily give you a reason why to do certain things. It can justify like certain moral systems over others and why they should be preferred on a rational basis, but it can't motivate you and push people towards those values and upholding those values like religion can, because religion gives you a sense in an afterlife, a reason to be good, and also it's more fundamental to people, as people have pointed out in this class. Religion is perceived as fundamental, whereas like philosophical rational justifications for morals is not in the same way. So I think without religion, people wouldn't have, in a general sense, socially, overall, as strong an adherence to these moral systems and codes. And so I think that if society would be less like well organized without religion, like there would be less reason to adhere to social norms and things of that nature without religion. So yeah, I think it provides a strong value to society.
Kind of piggybacking off what he said, I think like with the Yoder case, there's a historical basis of the sacramental use of Yoder in the Native American Church. And so I think that it would be prudent to look at that historical basis of that in consideration compared to your average donor who's true. There is no rational basis other than I just like the truth.
Yeah, Nick?
Even if you are saying that religion is good because on some level there's a higher power that's like, if you don't do these moral obligations, then not only will you be spanked in this life, you'll be spanked in the next one.
Spanked, yeah.
Like, can you also make an argument that it's more dangerous than peyote and more dangerous than shrooms because it leads a group of people to believe a certain thing and to choose certain actions that may not be in line with
All right. Let me. I guys. Well, I'm going to try and keep the discussion moving. Let me phrase this another way. So we discussed a couple weeks ago the marriage situation, right? And we said that historically, right, the state has privileged the institution of marriage. Why? Because it was understood that by creating this institution, it would encourage a man and a woman who make a kid to stay together for the child and hopefully make a better life for them. Did this work out in every case? Of course not. Did this make a lot of happy marriages? No. In fact, it probably kept people together who didn't want to be together. I think that's a safe thing to say. However, these things develop because society and whatever mechanism they have value this as something worth rewarding. And I think it's helpful to view religion in a similar lens, but at a far greater extent. Religion, to the extent that marriage predated society, religion predated religion. Religion predated marriage, right? Most marriages came about in some sort of religious function one way or the other. So I think one way of looking at this is perhaps one of the reasons, and I'm trying to synthesize what everyone's saying, is perhaps one of the reasons why society has given religion certain protections is because they've deemed it that it may make society better. It may actually make people more moral. It may make people more complying with the laws, which again, most laws were historically based on religion. So it made sense historically to peg or to connect religion and society. But let's also look at the marriage issue. In recent decades, right, marriage hasn't been quite as strong as it used to be. With no-fault divorce rates are sky high. And people say, oh, what difference does it make if people get married anymore, right? If we allow gays and lesbians to marry, that won't in any way impact the institution of marriage. right? Maybe it's wrong. So I want to pose a similar question, right? Maybe it's absolutely true that at one point religion was an essential component of our society's morality. But does that need to be the case? If religion doesn't create the sorts of benefits it once did, is it still something that ought to be protected to the extent of giving people exemptions from laws?
Isn't it like we're changing our beliefs now? Like the thing with marriage.
Who's we?
Like society.
Society is changing. Okay.
Women had to get married.
Okay.
You couldn't get jobs. I mean, and now religion, I think it's not providing the same benefits as it used to. I'm still talking to getting busy.
I'm sorry? You okay?
She just gave us one.
Oh, okay. Yeah, so I want to just walk around, make sure she's okay. Thank you. Yeah, I can never give blood. I faint also. It's not my thing. Would you actually hand up somewhere here? Yeah.
So you said that this benefit.
I didn't say anything. I'm synthesizing, right? I'm trying to keep this high level.
Your synthesis says that benefits as society as a whole has led to these exemptions and protections. For example, to allow a person to buy a jet. To this what's this
Creflo Dollar?
You know, like
Creflo Dollar. Right, that's right. What's his name?
Yeah.
Or a ticket by Costco, Austin, right? Well, so I mean, okay, so here, right? Here, I think you're moving on to something that is she okay? Is she all right? Did you call someone? She's fine. Okay. Okay. In another time, if she spoke ill of religion and she felt woozy, it would be a much different meaning of that. I remember once when I was in Sunday school years ago, I was saying something that was very anti-religious, and then my computer crashed today. I was like, all right, that's why. Like a floppy disk, my floppy thing broke. All right, but let's move. Yes, struck down by bolts of lightning at the podium, right? Let's move the discussion a little bit more, right? What if the sorts of benefits that perhaps Dylan is recognizing aren't there anymore? And what if the perhaps perceived benefits of religion are trying to buy private jets for a televangelist and doing other things that people don't like? Or to use an example from the reading, a religiously inspired company decides not to or opts not to provide various contraceptives to its female employees, right? At that point, the question becomes, are the benefits of religion worth continuing this sort of special protection? Right? Scotty, and I'll do Mirza next.
Just a real quick point on, I didn't think the Supreme Court mentioned, I don't know if it is worth mentioning or not. One argument that kept screaming out to me during this case was the Native American religious beliefs and the Native Americans in that region were ingesting peyote and practicing their religion and enjoying sweat lodges hundreds of years before we imposed our constitution on them.
Ooh.
So we were kind of the latecomers to this game. They were doing this before we got there.
Mm-hmm.
And I thought that might be kind of an argument to allow them to do their thing because they're, again, doing it before we.
So old religions are good, but new religions are not?
Well, they were there first.
I mean, so are new religions less privileged? Are new religions less worthy of sanction? The Pastafarians, right? The flying spaghetti monster we talked about a couple weeks ago.
Mormons' rights haven't always been respected.
I was going to say that, but you did first, which is just as well. Scientology? I don't know, was it 40, 50-year-old faith?
You mentioned society.
Oh, I'm sorry, Mirza. I skipped it. I'll come back in a second, Mirza. Oh, they do? They do? One at a time, guys. One at a time, please. Listen to your classmates. Thank you.
If I think about like organism, and then benefits provided like city providing a church and like some kind of beacon for like hope and like moral uprightness. And then you have civil rights growing out of churches, right? So you have these organized churches, actually government, and they also are used to like forward like civil rights programs. Like Dr. King
mentioned the no-fault divorce, right? Or to an extent implying a little bit of decline in that fabric or the idea of marriage or the institution.
Mm-hmm.
Taking the flip side of that, look at Italy, for example, where getting a divorce is probably about a 2-year process because of Catholicism, and that's led to an absolute decline in population. It's led to avoidance behavior towards marriage. It's led to an avoidance of women, for instance, joining the workforce or pursuing education. It's had an adverse effect. So where do you reconcile the balance? Or what's the middle ground for that?
Okay. All right, good discussion. Let me read a little bit. So Wisconsin v. Yoder, there was a passage which most of you probably skipped over, but was actually quite significant. The court tries to explain why religion is special. Justice Berger says, a way of life, however virtuous and admirable, may not be interposed as a barrier to a reasonable state regulation if it is based on purely secular considerations. Right? A way of life, if it's secular, that is non-religious, doesn't get any special protections. To have the protection of the religion clauses, the claims must be rooted in religious belief. Isn't that circular? To have protection of the religious clauses, they must be rooted in religious belief. So I only leave you with this discussion because I'm somewhat convinced that in your lifetimes, the arguments against religion in various capacities will continue to grow. You're already seeing this abroad, where various countries are revisiting whether, for example, churches should automatically get tax exemptions. And there's a question of whether a religious group that doesn't welcome all ought to be protected. Because of the decision in Employment Division versus Smith, perhaps Justice Scalia's maybe most unpopular decision, the Constitution doesn't really have much teeth anymore with the Free Exercise Clause. And what's only standing in the way is the Religious Freedom Restoration Act, RFRA. We'll get to in a few minutes. Now, as you noted in the thing I had you read that I wrote in National Review, the federal RFRA has been around for 20-something years. And a number of states enacted RFRAs. Those may not be in the books forever. Other states are trying to enact their own RFRAs, Indiana and elsewhere, are suddenly viewed as doing it for different motives than when they were first designed. So I think the idea of the RFRA is probably not going to be with us for a very long time. I think states will begin repealing theirs. And underlying these repeals will be the question I asked you at the beginning of the class. Why is religion special? Why does it warrant any sort of privilege or special place in our society? And unless you're able to muster up the sorts of arguments that a number of you did and make those arguments persuasively, the opposite position will prevail. And because we're talking about statutes and not constitutional law, they can be repealed by simple majority vote. And that's perhaps the most enduring legacy of Justice Scalia's free speech jurisprudence. I'm sure he would take this one back if he could, or maybe not, I don't know. Okay? Good questions on that. Keep that one in mind. You'll probably forget everything else I say, but this one may stick with you, hopefully. Maybe not, I don't know. All right. So the actual reading and the things that I assigned for you, not this nice discourse on religion, begins with an anonymous petition authored by James Madison called the Memorial and Remonstrance Against Religious Assessments. To remonstrate means to protest something. It's a fancy word for protest. And the situation of this was like this. Patrick Henry, a great patriot, proposed a tax in Virginia paid for the support of religion. And people could either pay this tax and support a church of their choice, or if they're not religion, they could support some sort of other seminary of learning. Right? But this was legitimately a tax. And at the time, I think one of you mentioned this, many of the states in the colonies had established churches. Massachusetts, Maryland, and others had established churches. In England, there was an established church, the Church of England, and the members of the state were subject to taxes to pay for this. So there was a long history of the state and church being one, and taxes were being imposed on the citizens to support that religious institution. Madison's arguments, though, were very powerful to the contrary. He doesn't see this problem as one of establishment in what we would call today, right? His problem is not that the state was getting involved in religion. His problem was that by forcing someone to support a specific religion or a church, it gets in between them and their creator. At the time of the American founding, the Revolution, there was a strong notion of the creator. And a few of you mentioned natural rights. If you look at the very Declaration of Independence, just studying the first class with you, we are endowed by our creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness. There was a strong belief that God, whoever he or she may be, gave us these freedoms which we possess, and they cannot be alienated. That is, they cannot be given away by any government charter. But to understand that relationship, Madison writes, is a personal one. It depends on a man's dictates and their conscience, what they think is their duty towards their creator. Okay? So even those who perhaps haven't recognized that this creator, this is this amazing thing, we still have to protect those people, right? Because not everyone has that sort of relationship. This wasn't Madison's defense of atheism, and I'll make that point clearly. He was certainly saying that those who have this relationship with the creator were better off. But what he's saying is not everyone is there yet. And by imposing this tax, we would be infringing upon the bond, that enduring relationship with the Almighty. Okay? So this paper, this petition, was of course anonymous and written 6 or 7 years before the First Amendment was ratified, but it's often viewed as an authoritative statement of what the meaning of free exercise is, that people have the right to establish their own bond with their creator, and almost a right of conscience, that they can't be forced to take actions that are inconsistent with that system of beliefs. Some questions about Madison's memorial remonstrance. Nothing. Is she okay?
She is. Mm-hmm.
Yeah. Okay, that's fine.
We brought her some vodka. She's good.
Yeah, thin the blood even more, right?
She just gave donated blood, so she just.
Yeah, you should not give blood before class. It's I tried doing a blood test and I totally fainted. Didn't work out, so not gonna do that again. Not gonna do that again. All right, any other questions? All right, then let's move on to the first case, Wisconsin v. Yoder. All right, I think Larry, you're up next. Reasonably prudent lawyer. Okay, go for it. Please, what were the facts in Yoder, please?
So there were 3 Amish students from 3 different families that wanted to stop. Their parents pulled them out of attending high school because they felt that after 8th grade they didn't need further education because it went against their religious beliefs of their community. So they took it to trial because it went against a statute that said that you had to go at least through high school. But they claimed based on their religious preference that it went against the First and 14th Amendment.
Okay, very good. So Wisconsin, like most states, had a compulsory education law. The law required that students attend school until the age of 16. So basically, it was a sophomore, junior high school, whatever that happens to be. Now, Robin, let me ask you a question, please. Was this law enacted in any respect to punish or infringe upon the beliefs of the Amish? Why was this law enacted? If you had to, I mean, if you had to guess, you don't know, but I mean, take a guess. Okay, so everyone agree with Robin. I think she's right that this was not passed as some sort of Amish bashing bill. That they're sick and tired of those horses and carriages and all these other This was not based on animus towards Amish. We're okay with that? Okay. So by way of review, we did a case. Katie Cupcake Cookie, thank you very much. We did a case about a month ago where also the state tried passing a law concerning education. Remember what case that was? Another one. That sent kids to school. You want that? You can go. What's that? What? I can't hear. What?
You can phone a friend.
Yeah, you can phone a friend. Which one? Who got it? Pierce v. Society of Sisters. Remember that case? What was it about?
Yes.
Okay, tell me.
So that was the one where they were like the Catholic students, and they basically did they defund the money from.
Oh, so close, so close. You remember, Sarah? Ashley? No, they did something very different. Good. So you remember I talked about this case, Pierce v. Society of Sisters. So very good. And basically, Oregon passed a law which shut down private schools. They said, well, you can stay open, but all parents are obligated to send their kids to public schools. So obviously, these private schools go out of business because they have no students to teach. Now, I think Katie said it correctly. This law was passed of an anti-Catholic animus. There's not a doubt about this. They were afraid. I mean, I've actually read. They viewed Catholic schools as equivalent of madrasas today, as like these like indoctrination centers for papism, worship of the Pope. So they shut down these schools by private students. Now, that was a substantive due process case. We did that in the Lochner topic, where the court held that parents have the right to direct the upbringing of their children, that this was a 14th Amendment right. It was not, as the court would later suggest, premised on the Free Exercise Clause. Indeed, the Free Exercise Clause had not yet even been incorporated to the states. Okay? So, let's see. I'll ask Ashley, why didn't the court just say Pierce Society of Sisters, and then the parents can decide to bring their children? Done. We don't have to do the First Amendment. Why didn't they just do that? Why wasn't that the resolution of this case? What's the big difference, Ashley, between Pierce and this? What is the difference in the facts here? In terms of parents, what's the big difference in what the parents are doing? Okay. In Pierce, were the kids getting an education either way? In this case, they're getting education either way. What's the difference? Okay. So I mean, on one level, right? What's the difference with Pierce? In Pierce, they want to send their kids to a school, but the school is of a private nature. Here, they're saying no school at all. Okay, so I mean that's one difference. The other difference, which was the answer I was more looking for, is that Lochner's evil, and that the court can't cite a decision premised on Lochner. That's really the other reason. But they mention it, but that can't be the basis. In fact, if you actually read it, they actually try to repurpose Yoder as a First Amendment case, they try to repurpose Pierce as a First Amendment case, which it was most certainly not. Okay? So this here raises the question, right? I think everyone in this room would agree that the state has an interest, generally speaking, in children of a certain age having an education. And I think everyone would agree also that this law was not enacted in any way to single out Amish for persecution. This was a generally, what we call a generally applicable statute, that applies evenly to everyone before the state. It doesn't say Amish have to go to school for this, and then whites and this, and blacks for this. This is a pretty evenly drawn statute. So what are the Yoders asking for here, right, Luis? What are the Yoders asking for here? Right, so what are they, with respect to this, there's a criminal law, they have to face a penalty. What are they asking for with respect to that law? Yeah, so you can go this one way, right? An accommodation. Right? Maybe we call this a religious accommodation. Maybe call it a religious exemption. But they're basically asking for special treatment under the law, right? Luis S., what happens if, I'm a farmer in Wisconsin, right? And I need my son to help me work with the farm. So I take him out of school and he's 14 years old because I need to help him on the farm. I'm not religious, I'm an atheist, but man, my farm it's a big farm, right? And I say, look, these Amish guys, they got to exclude their kids from their school because of religion. I need to leave. I need to eat. I need my family. I need my son to help me with this farm. And they're going to fine me if I take my kid out of school. What gives? What gives there? I'm asking you. Okay. Who says, yeah. B? No. Oh, did I say? Oh, I'm one off. Okay, yeah. Sorry. Yeah, Luis. B.
Well, the interest is not the same because one is religious and the other one.
Yeah, but that's the question I asked you 20 minutes ago. Right? Why is it that the Amish can exclude their kids from school because of the belief in whatever society they have versus a farmer who needs his kid to live? I mean, it's like if I don't have my son helping me grow these crops, my crops are going to go bad. I'm going to die. I don't have any food. I'll go to the poorhouse. Why are we giving exemption to one, not the other?
Because the Amish are going to teach them, while the other one is just going to find them work.
He's trying to be a farmer. That's important knowledge.
But it's not the same
That's who.
knowledge.
That's who.
One's religion and one's belief.
Well, I mean, the Amish are basically saying if he goes to school, he'll be spiritually dead, right? And the father's saying if he goes to school, I'm going to be actually dead because I can't feed myself. Right? Becca, you want to take a step?
I don't think there's a difference if there's that type of hardship. Like, I mean, just I know modern today we have work acceptance, things like that. To be able to go only like 4 hours and then work, I mean, that was back then, but I see it's technically the same. I mean, if you're gonna not be able to provide for yourself, unless your kid, why do they homeschool?
Oh, homeschooling, right? Okay. So I think here we've more or less drilled down to the same issue again. The court basically says that a secular reason for keeping your kid home, that is helping him on the farm, that won't cut it. But a religious one will. Now, I think here the reason why it matters, and again, removing myself from the hypothetical, is we have a First Amendment. And the First Amendment protects the free exercise of religion. It doesn't protect non-secular beliefs. So we have a Constitution, this is pre-Smith, we have a Constitution that puts religion on a pedestal, that puts it somewhere special. So I think that fully justifies the court in explaining that we're going to protect the parent who's an Amish kid and not the farmer. I think that's entirely defensible based on the First Amendment. And I think the court makes that point, right?
So does this allow the people that believe in spaghetti or whatever?
The flying spaghetti monster, please be respectful. This is not pasta, this is faith.
So if they have similar beliefs that are rooted in their noodle person, like
Flying spaghetti monster, you're blasphemy, man.
I'm sorry. So does that allow them to,
Take a picture with a colander in their head?
yeah, Yes.
All right, so this is the issue. I'll answer your question, right? This group, the Church of the Flying Spaghetti Monster, there was actually a decision about this about a week or two ago. I should have sent it around. You actually had a judge who writes, you know, this religion may have been started as satire. Maybe people believe it or not, but effectively the entire thing's a joke, and it's basically a satire religion. And the court held that this was not a religion for purposes of the First Amendment. These are tricky things for a judge to say, right? That something is not a religion for the purpose of the First Amendment. Maybe to Scotty and Samuel's point before, how long must a religion be around before it's considered a religion? I mean, Scientology is, what, about 40, 50 years old? The Mormon Church is, what, about 150 years old, give or take? You know, Protestantism is about 400 years old. Zoroastrian goes way back. You know, I mean, we have some pretty old religions. Yeah, Natalie. Really? Like the war on Christmas, or what are you talking about?
After the gay marriage bill passed, refused to give marriage license to a gay couple, like she would rather sit in jail than give this marriage license. So people who, I mean, for whatever reason, there would be a civil disobedience against government regulations that violate their religion. So I think in fact, if the government didn't make allowances for religion, that the state police power would be diminished.
So let's talk about this for a minute, okay? Because this is actually a Kim Davis in Rowan County, Kentucky. This is actually a very widely misunderstood episode. People don't actually understand what this was. I'll give you a rule of thumb. If there's any controversial issue affecting gay rights, read it again, because people don't actually understand what's going on. If for whatever reason, this topic engenders people to react in a way that's often divorced from reason. So what happened in Kentucky was this. Even before the Supreme Court dropped the decision in Burwell, Kim Davis and others had been petitioning the state to modify the marriage license, right? Because the marriage license has a little slot where it says, I am authorizing this under the power vested in me. Kentucky has a RFRA, a Religious Freedom Restoration Act, as does Texas and many other states, which generally says you can give an accommodation to someone to avoid a substantial burden on the religion. That is, if you can achieve the same state interest without burdening religion, you should do it. So they were asking for months before the decision to please amend the form, take the name off. So after Burwell dropped, Davis, and this was not a surprise, she knew this was coming, refused to sign the forms. This was litigated back and forth, and ultimately she went to jail because she refused to sign the forms because in their present form, it had her authority in it. Whether that was right or wrong as a matter of law, I don't think it matters because in her belief system, that's how she found a burden. After the subsequent election of governor of Kentucky, Matt Bevins, a Republican, changed the form, and he removed the name from it. Now there's no problem. The form is being issued just fine. There was actually an accommodation that could have been granted under RFRA. A similar issue happened in Texas, where the Texas Attorney General issued a memorandum, which said that if any individual in a clerk's office does not wish to facilitate in a same-sex wedding, he or she can be asked to be reassigned and to be put somewhere else, do death certificates or property tax, whatever else. And what the AG said was, as long as there's someone in the office who can provide these licenses in a timely, expedient manner, okay, then that's fine. Now, if there's no one in the office and no one objects, then they have a constitutional issue. So a lot of these issues have actually one of RFRA rather than the First Amendment. They have various accommodations that can be given to people who find that participating in this is morally objectionable. But if we go back to Justice Kennedy's opinion in Burwell, he had this line about how, religions are free to continue to preach and discuss, but not exercise. He didn't put the word exercise in there. And when you have these sorts of decisions that a significant portion of society still objects to, it's unsurprising that you have these sorts of disputes where groups are now relying on RFRA to seek exemptions or accommodations to otherwise generally applicable laws. The irony, of course, is that Justice Scalia's opinion in Smith Scalia, the most staunch defender, his dissent in Obergefell was strident. His opinion paved the way for this as a matter of constitutional law. Okay. John, your hand was up a minute ago?
Yeah, because I think Dylan had a question. I don't think we answered. So
Okay.
I thought his question was hitting at that. Look, it's not just about, getting tax exemptions per se, but there's certain conduct that, religious organizations may allow or permit or be a part of their custom. It's just illegal. Right? Like, it's just like against, you can think of, first that came to mind was like cannibalism or something.
Human sacrifice, maybe.
Yeah, and sacrificing or cannibalism or something. Or, yeah, whatever. Something like that just seems clearly illegal. And there's no way you can cut it out. Like, it's right there in the doctrine. You can think of, and you may have factors whatever that, Stan mentioned, but like, you can think of like Catholic Church, some reformed version of Catholic Church that says, look, we can now eat the body of Christ or something. Body of Christ is now reformed to eat something else. So you can get away all the little factors and the little whatever to get out of it. I just don't see that a government can actually, US government be able to say no.
So I mean, we haven't got to it yet. So you actually go to Scalia's opinion then. Okay. I think the difference is you said stuff that's against the law, right? Here in the Wisconsin one, was there actually a crime being committed? What? See,
no, so, yeah, exactly.
that's perhaps one distinction, but we'll get there in a few minutes. What else? Yes, I know.
I was just what struck me with the whole Kim Davis thing. I get that, but it's like if I went to work for the penitentiary system and I applied for the job to be executioner and then said, well, actually, my religion, I don't believe in the death penalty. Well, don't apply for the job.
So what if you're a flight attendant who practices Islam and doesn't want to serve alcohol? Or if you're a taxi driver who practices Islam and doesn't want to transport someone with alcohol? These are actual cases. I mean, these are cases going through the pipeline now. Okay. They're actually, the other issue is she was actually elected. She wasn't hired, and she was perhaps elected with a constitutional understanding that was changed by the Supreme Court a few months ago. So perhaps there's that. But we generally have a tradition of accommodation for religious beliefs. This is not something that's germane to the last 3 years. It existed long before. The case actually at issue in Smith was a case called Sherbert versus Werner. The case of facts were like this. You had a Seventh-day Adventist. The Seventh-day Adventists practiced the Sabbath on Saturday instead of Sunday. That's their holy day. And you had a guy who was basically unemployed. And he said, hey, state, I want some unemployment benefits. And the state said, okay, we're not going to give you the benefits. There's this job for you. It's on Saturday. It's awesome. Go work there. And the guy's like, hey, I can't work there. My Sabbath is on Saturday. And the state says, okay, that's fine. Then you don't get any benefits, right? You're not willing to work when we tell you to go work. And the Supreme Court said that someone shouldn't be forced to choose between their faith and some sort of statutory government benefit, right? Now, I suppose we're hiring as an executioner being opposed to death penalty may be a somewhat extreme example, but there are an entire manner of jobs where you can fully comply with your job subject to certain accommodations.
So my question is, when Greg Abbott said that we're going to use the Religious Freedom Act to fight the Supreme Court's decision, what was he referring to? Was he talking about constitutional things too, and how he could implement that?
Well, I think it would be Attorney General taxing because Abbott was already was the AG by the time, but the Texas RFRA, the Texas Religious Freedom allows people to request accommodation. I think that's what he's referring to. We have a statute, Texas enacted a RFRA, very similar to the federal one. That's your question?
But did that work?
Well, I don't know what this is referring to. What's this?
I mean, using the Texas Freedom Religion to fight or.
But I don't know. What's fighting?
I mean, it's this religious freedom conflict is in conflict with the decision of the Supreme Court.
Are you talking about people handing out the licenses? I'm not sure what you're referring to.
Licenses. Yeah. So
I think it's the accommodations work so far. I mean, in every county in Texas right now, one can obtain a license. Although there might be individual employees who are exempted from providing them.
So how about Texas religious freedom?
And they were doing that under the auspices of Texas RFRA. That's what allows them to do this. All right. Did I answer your question? All right, Scotty, then we'll finish Yoder and move on.
I had a question. I don't know if I should ask it now or later, but is the United States versus Lee, the 1982 case allowing the Amish to not pay Social Security taxes, is that still good law? Because I know the Social Security Administration finally caved and allows the Amish to apply for a waiver so long as they never reflect Social Security. So does Lee still have any?
Well, yes, Lee is still good law. And to answer your question, what the IRS did was not a matter of constitutional law, but an accommodation based on their own goodwill. They're not required to.
That's not an accommodation.
Right, because the issue is if it was compelled by the First Amendment, other groups would have to get the same deal. But if it's something they decide to have the goodness of their heart, they can just single out the Amish. Dan, and last question.
I seem to see a circle here, but perhaps the Supreme Court recognizes religion as an institution, so it doesn't look at very small little segments and what have you, correct? But all these are individual objections, not institutional objections in terms of an established faith, like we talked about in terms of right. How come that never gets reconciled?
I don't think I understand your question. I'm sorry. What do you mean? What do you mean institutional?
For instance, with Catholicism, it's an institution. The Amish, it's somewhat of a institution in terms of a very well-established faith.
Okay.
But all these objections are individual objections.
Well, the state doesn't throw religions in jail. The state throws in jail people who don't send their kids to school. Right? All these cases begin because someone's trying to prosecute a law against an individual. It's not that the Seventh-day Adventist Church is being persecuted. It's that one guy who's being denied employment benefits is suing. Right? I mean, all these cases involve individuals who think they're being denied various rights because of their faith. It's not going to be Catholic Church versus state. That's not how the suit would emerge. Maybe I don't understand your question. I'm sorry.
I guess what I'm asking is how come most of these objections are not recognized within those particular faiths, but they're really, it all boils down to the individual objections.
I don't know what you mean, but the Amish as a church as a whole, they oppose schooling over 14. I don't know what your point is.
And so wouldn't you think that that contradicts or it's opposed to the state interest rather than a guy saying, well, my faith says this.
I think the claim in Yoder is entirely consistent with teaching the Amish Church. I think the claims that Sherber raised are consistent with that of the Seventh-day Adventists. I mean, I'm not sure your point is, but their beliefs are well within the mainstream of what their faiths say. Taylor?
I think kind of what this might not be what Dan was asking, but sort of along those lines. You know, in Yoder, it's very clearly part of the Amish faith, whereas in some other more recent issues, being opposed to gay marriage is not the same kind of religious belief. Like, you may be opposed to being married or being gay, but being opposed to other people and their gay marriage is not quite the same as saying my kid should not have to go to school because that's against their religious beliefs.
I see. So your point is, I'm not sure this is Dan asking, is so right. So is your position that religion shouldn't care what other people do quite strongly?
And also being related to the fact that, I mean, this is one person saying what their religious beliefs are, but is that really what the religious beliefs of the religion are? And where do you draw the line of my religious beliefs? What is?
So your point is for a Christian or a Catholic to say, I oppose others getting married is not necessarily consistent with Christian teachings.
I would argue that it's not in the same way that an Amish believe that their children should not go to school past the 8th grade. I would say they're not the same.
Okay, so that's your
point. Where do
point.
you draw the line? I guess is a question. How do you determine whether someone's like the stoner just claiming this is part of my religion?
Well, I think, I mean, respectfully, with respect to gay marriage, I mean, the Pope has spoken on this issue. I mean, there's a pretty big teaching against gay marriage in most, mainline Christian religions. I don't think it's even a close call.
But not in the same sense. I mean,
no, it is. I mean,
the issue is I don't want.
But religion, and it is something which is difficult to understand. But religion is not just premise what you do, but what society does. They want a good society. So I think, respectfully, the teachings of most major religions are pretty clear on this. I mean, not all, but most Catholic, mainstream Protestant religions, and others have pretty clear teachings on what society should allow.
Right. Then let me be more
Yeah.
clear. There's nowhere in any Christian teaching that says you can't make a cake for a gay couple. It's crossing a line. So where do you?
I don't, I'm not a theologian, and I don't think the debate's appropriate. I think that's probably wrong. Yeah, I mean, I'm not a Christian either, but in terms of, I'll approach this from Little Sisters of the Poor, which is a case I actually do much more about because I've actually talked with this. But the issue in the Little Sisters of the Poor case is interesting, right? The Affordable Care Act, it's really the implementations, implementing it. The ACA provides something called a preventive care mandate, which requires most employers to provide a form of contraceptives to their employees. Okay. After a number of various battles back and forth, the federal government effectively said, well, we'll tell you what, we can't force the Little Sisters of the Poor to pay for these contraceptives, even though the Little Sisters want to take it themselves, right? It's their employees who can take it. What we'll do is the government will pay for these contraceptives, and then we will use the plans of the Little Sisters of the Poor to provide these contraceptives through it. So it's not like they're going to go on the Obamacare exchange and get a contraceptive plan. So the Little Sisters said, wait a minute, we're complicit in sin. Even though we're not taking contraceptives, and we don't have to take the contraceptives, by being part of this process, we are complicit in sin. I've actually done interviews. It's a doctrine of scandal, if anyone know, right? If you yourself are associated with something that's sinful, you yourself are committing the sin. And there's actually a mainline Catholic teaching. So even though the Little Sisters are not themselves engaging the sin, by being part of it, they feel sinful. Whether it's a RFRA violation, I think is a close call. But in terms of religious teaching, being part of someone else's sin is indeed something that that they feel morally opposed to. Does that address it?
Well, I think it got away from my question. My question was simply, how does the government determine when something is infringing on your religious beliefs?
Right. But no, your second point was, if it affects someone else, it doesn't affect religion, period. I don't think that's not right. Yeah, is there a hand up there?
Yeah, I just said it with the whole Catholic doctrine that says you can't use contraceptives, also says you can't use things like Viagra. But there are plans that provide Viagra, and they're not suing the Supreme Court over that.
Well, you don't sue the Supreme Court, but
sorry, they're suing the states.
Right. What's interesting is the what are called church plans have long exempted all these sorts of products.
No, but I mean, that's still just that they're just wrong with their own doctrine. They don't know what they're talking about.
Okay.
I think the question is, how do the courts evaluate these determinations on an individual level? So I can say, like, it's against my religion. I have to sit in class and listen to black men talk about religion or something. And then how would they go and say, like, look at the Bible. Does the Bible say it? Like, what are we looking at as a court to determine whether or not that's a legitimate claim under a particular religion, and where are you drawing the line between a legitimate claim under that religion and an illegitimate claim under that religion?
So for the most part, and this moves more towards the Smith case from RFRA after it, courts don't get into the business of questioning what the beliefs of a faith are, for the reasons you two have raised. It becomes very difficult to challenge what, in fact, the doctrines of faith are. The question is whether a person adheres to those doctrines and whether those beliefs are genuinely held. So, for example, during the Vietnam War, a lot of people suddenly found the Amish faith very attractive. Why? They were draft dodgers. The Amish faith had various exemptions to the draft, and you suddenly had all these hippies claiming to be Amish. Was that a genuinely held belief? A lot of courts said no, that you simply adopted this as a matter of convenience. Right? Is a stoner who suddenly gets arrested for eating peyote like, oh man, I just found out I'm a Native American, right? I just found out. Revelation hit me like a bolt of lightning. Or are you like Mr. Smith, who had found the religion and embraced it? So for the exact reason I think that this debate happens, courts don't question what the doctrines of a faith are. Right? They don't question whether, in fact, the Catholic Church has one position or another. It's a very contentious issue. They do question whether the person genuinely holds that belief. So let me finish up Yoder, because we never quite got that far. But the court basically held that even for laws of general applicability, if it unduly burdens a free exercise, the government has to give an exemption, right? Even if this educational law was passed with clean hearts and no effect of religion, if it unduly burdens faith, it cannot stand. This doctrine has been stated in many ways, but if there's a substantial burden or an undue burden, sounds like Casey, doesn't it, right? It cannot stand. The doctrine of Yoder and Werner are of dubious consistency. In other words, the court didn't consistently apply it. So Scotty mentioned the Lee case. It's not clear if the court in Lee actually applied Yoder and Werner. This was a case where the Amish asked for an exemption from Social Security because they deemed it basically sinful, that they didn't want to be involved in this retirement scheme, which was contrary to their beliefs. The Amish have very rigorous beliefs, you can tell. They have very devout system of faith. And the court said, too bad, you have to pay Social Security. Now, Scotty's right. They gave him a statutory exemption, but that's quite different from a constitutional exemption. But this led up to the 1990 case of Employment Division against Smith. And this case revisited the issue of whether a law of general applicability, that is, a law that applies to everyone equally with respect to religion, violates the First Amendment. Okay. So, Mirza, run me through the facts, please, of Smith.
There was a state working with had a criminal prohibition on disability use, and basically this prohibition permits them to deny unemployment benefits.
Well, give me the facts. What did Mr. Smith do here? Just go back a step. What did Mr. Smith do? That's Al Smith, by the way.
They were working at a drug rehab facility. They said it's very effective.
Okay. Anyone know about this? I actually had a student a couple years ago engaged in this ritual. Anyone have any experience with this? Right. So.
Oh, sorry.
Yeah, go for it. Go for it if you know anything. Yeah. Use it with what?
They use like quit drugs. Like,
quit? Oh, quit. Oh.
Yeah, so it's like kind of like a drug that hypnotizes you and like stopping some bad habit you're thinking about. So you take it with the intention of like, hey, I want to like relinquish like burden in my life, and then like Mother Ayahuasca comes to like talk to you and like it was on Netflix.
Oh, okay. Well, you can just chill. Okay. Thank you. You have any?
Yeah, so I think that the ayahuasca is the one that's dealing with the religious tea case.
That's actually something else. I didn't want to say anything, but yeah, that's something else. You're on a roll. Peyote and ayahuasca is different, yeah, but they're different. They're different sacraments. Scotty?
Well, the peyote can actually be taken as the tea. I mean, that's one of the easier ways to get in your body.
It's apparently very violent to eat.
Yeah, if you eat it, it's rough to say the least. The nausea, the diarrhea, like it tears you asunder. But if you have it as oil, it's not as bad in your body. The gentlest way to get it in you is have it steeped in the tea.
Thank you, Scotty. You learn something every day, huh? Anyway, so no, I had a student a year or two ago who actually engaged in this ritual. And basically, it's this entire ceremony where they're chanting and they're praying and they're singing, and they basically take slices of this cactus, which you have to eat. And he told me it's very tough to eat. It does not go down smooth. But anyway, it's this tradition. Yeah.
Watch Young Guns.
Young Guns, it's in that movie?
Yeah, it's a movie.
Okay.
There's one guy's name.
Oh yeah? I've never ingested, so I wouldn't know, but I assume it's it's a very solemn ritual. It's been done for hundreds of years, long before white man came, but so Smith lost his job. He went to go apply for unemployment benefits. He was denied benefits because his cause for termination was involving drugs. Right. In other words, I hope none of you ever have to do this, but if you want to go to apply for unemployment benefits, there are a number of exemptions, right? And if you were fired for some sort of bad reason, the state has ground to deny you benefits. And in this case, the reason why he was denied benefits was because he had ingested this peyote, which is a controlled substance under federal and Oregon law. Okay? So he challenges then the denial of the unemployment benefits as a violation of his religious liberty, as a violation of his free exercise rights. Okay, everyone get the facts, right? All right, Tariq, how is this case then different than Sherbert versus Werner, the case I mentioned a few minutes ago, where the Seventh-day Adventist was denied his unemployment benefits for not working on a Saturday, the Sabbath?
They said that there's a controlling state interest behind that decision, that Saturday case, that's really going to be in conflict with the normal working hours that the Constitution of the state has organized. But in this case, they didn't, when the state of Oregon had enacted that law, they didn't put in consideration those people who lose people with this special set.
Let me ask the question again. I think you answered, I'm not sure. What's the distinction between Sherbert versus Werner in this case? I think you answered it. I think you walked around it. What's the major distinction between Sherbert and Werner in this case from Justice Scalia's perspective? Okay. So what was the state's interest in Sherbert?
It's preserving the system or not tackling the life.
What's the compelling state interest in this case? Yeah. So is that not compelling? Yeah. What's the difference then between Sherbert and this case? Because he was engaged in criminal activity. Okay. So let me give you the right answer and then the real answer, okay? The answer Justice Scalia gives is exactly what Jacob said a minute ago. Scalia's like, look, in all these other cases, no one was breaking the law. Right? Deciding not to work on a Saturday, perfectly lawful conduct. Here, the crime was using a controlled substance. In other words, the religious act itself was illegal. Right? Having your kids working on your Amish farm and teaching them about the the ways of the old order, right? That's not illegal. That's perfectly lawful conduct. Here, the conduct that was unlawful was the actual religious ceremony. It was against the law to use these controlled substances. So Justice Scalia makes a very big deal about the fact that we are now dealing with illegal conduct. Okay, John?
Yeah. So isn't the child labor, couldn't you argue that the kid having to not go to school is like child labor? Isn't that also illegal?
Is
He's
it?
doing it for his family and not get paid for it.
Is child labor on your family farm illegal? Guy shaking his head no. The short answer is no. Most states have child labor laws, but working on your family farm is probably okay.
Well, not going to school and having to do
Well,
that.
but that's the issue. They criminalize that, right? It's otherwise lawful conduct that they start to criminalize. Here, the peyote was illegal irrespective of the actual unemployment statute at issue, right? In other words, what happens if the state had arrested Mr. Smith for using peyote, right? They just busted him. That using peyote to control substances. And he said, well, this is my religious sacrament. What do you think would happen there?
I think we probably would have gone the other way because he wasn't seeking a benefit.
So you think you could have actually gotten by?
No, sorry, it would have been like that.
I'm sorry. If they busted him for marijuana, do you think they could have convicted him? Why?
Well, it wouldn't have been, if you're saying marijuana, it wouldn't have been part of the rules.
I said peyote, I'm sorry. They said marijuana, I meant peyote.
Yeah.
I meant peyote, sorry.
Okay. Well, I mean, they make a distinction between like a belief and an act. That I think not like happens, but it is the act itself that is criminalized.
So what's interesting here, right, is that this is noted, I think, in the dissent. There was never any effort to prosecute Mr. Smith for the actual drug violation. There's never any effort. I think you'd have a very tough decision if you're a prosecutor of raiding a sweat lodge and busting up a bunch of guys eating peyote in a religious situation. I think you'd have a very tough case. I think there's actually prosecutorial discretion in that as well. I'm not sure how it would come out. You actually have cases recently with the Church of Marijuana or something like that, right? They tried to make a cannabis church. And I think there the court said that this is not a real religion, that you're just a bunch of stoners trying to get high. But this issue has come up. But I wanted to go back to the point I was raising before. On its face, Scalia is drawing this distinction between, criminal conduct, legal conduct. But what's really going on here is that the court's overturning Sherbert. They don't say it, but they are. And Justice O'Connor's concurring, really, a dissent. But O'Connor's opinion makes clear, look, they're reversing Sherbert. I mean, they don't quite say it, but take my word for it. That's what's going on here, right? So the question then becomes, right, Austin, why do you think Justice Scalia, who by all accounts is a very pious man, is so intent on overturning Sherbert and Yoder and these other sorts of cases? Why do you think he's so intent on getting rid of these cases, or at least reducing them to such a narrow set of facts that it won't even matter anymore?
I'm not sure.
I'm asking you, what do you think troubled Justice Scalia, knowing what we know about Scalia? You've been in this class now 28 days, right? Knowing what we know about Scalia, what do you think bothered him the most about cases like Yoder and Sherbert?
I'm not sure.
Zach?
I guess he refers to under the Sherbert test, governmental action is substantially a burden of religious practice as justified by compelling governmental interests. And probably just too broad, I guess.
What power does Sherbert give to courts? Think of that in terms of Scalia legal ML. What power do courts get as a result of Sherbert and Yoder?
Freedom to prohibit religious activity.
What power do the courts get for themselves?
They kind of get to act like in a legislative.
Exactly. Okay. Scalia's gripe, at least for his first couple years on the bench, maybe not so much afterwards, is he doesn't want courts exercising this sort of legislative power. Sherbert and Yoder gives courts the power to carve out exemptions where the state otherwise did not. Sherbert and Yoder allow the courts to carve out exemptions where the state otherwise would not have. So think about this, right? A number of states and the federal government created exemptions to this controlled substance laws for peyote, right? That was noted. A number of states made that decision. Oregon did not. They could have. They didn't. Other states did. What Sherbert and Yoder allow them to do would be judges come in and say, you know what? Even though the legislative branch decided not to give this special protection, we'll do it for you. And it allows, in effect, a religion to become a law unto itself. Right? Scalia says, you know, if the state wants to ban polygamy, and indeed Utah and other states, their admission to the union was contingent upon eliminating polygamy, are we now going to say that a polygamist can say, well, this burdens my religion. I want to have 3 wives, sister wives. How many do they have? 7? 4? Okay, 4. But whatever it is, right? This was something that troubled Scalia and Rehnquist and others for many years. The idea that courts could be freewheeling, creating exemptions for religious accommodations, and exempting groups from these laws. The irony is, later, the most steadfast defenders of RFRA become the conservative justices. But we'll get there. We'll get there in a few minutes. So Scalia effectively says, for a law of general applicability, right? Unless there's evidence that there was animus, right? Unless there's evidence that they were trying to single out religion, the law is fine. Unless there's evidence that they really did this to single out religion, the law is fine. We're not going to get to the sort of balancing test where we figure out whether there's a burden or this or that. As long as the law is general, unless it was singling out religion, the court will not intervene. Scalia says, leave the rest to the democratic process. Other states have exempted peyote, so too can Oregon. It's not necessary for the court to do so. And this effectively overturned Sherbert. Everyone get the majority opinion, Scalia's majority. Okay. Any questions on the majority? I want to turn briefly to another case later, Church of the Lukumi. We'll come back to O'Connor in a minute. But Church of the Lukumi is an example of how the court has applied Smith. So, Michelle, what were the facts in Church of the Lukumi, please? Yeah. Oh. Oh, you're calling it someone else we called it when you're two spots away. Who did I? I'm sorry. No, I called on Zach, then went to Shelby. What are you talking about? Oh, I skipped all of you guys. Wow, someone's getting Classmate of the Day award. All right, fine. Zachary, I think you're next.
Yes,
Wow, look at a backbencher, man. Michelle, I'm sorry. Zachary, Sarah, tell me, what were the facts in Church of Lukumi, please? God, man. You didn't read it. Okay, Helen? Now he's really mad at you.
Okay, so the court held that there's an ordinance, the outlaw animal sacrifice.
Well, did the outlaw animal sacrifice? What did the actual law say, though?
The law was out, the ordinance was outlawing animal sacrifice, and the Supreme Court said that that was not constitutional.
Okay, well, really close. So you're really close. So the case effect of the Santeria faith. Everyone know about this? It's basically an Afro-Caribbean faith, and part of the sacrament is they perform animal sacrifice. They slaughter a chicken in a ceremony. Are you okay? Okay. They slaughter a chicken in a ceremony, and this is part of their religious beliefs. The city of Hialeah, Florida, didn't like this very much. So they said, I got an idea. We want to stop this thing from going on. So they couldn't pass law saying we are banning Santeria sacrifice, right? That would be constitutional to make your head spin. Instead, they said, well, we'll ban certain types of animal cruelty, right? And the way they framed the statute, on its face, it looked like a general law protecting animal rights and avoiding animal cruelty, right? But if you actually read it, it made it very clear it's only applied to the way you would kill the chicken in the Santeria ceremony. In other words, they weren't concerned with other butcher shops, right? They were trying to single out this one specific religious practice. The Supreme Court said, even under Smith, right, even under Appointed Division versus Smith, this is no good. It's not really a law of general applicability. It might look like it on its face, but this was truly a law designed to single out a specific element of the Santeria faith. So even under Smith, some stuff gets struck down. But that's only when the law is actually designed to single out a specific faith. If it's a law as general applicable, then that doesn't work. So everyone get the Church of Lukumi case. Okay? All right, so Clayton, let's go back to the concurring and really it's a dissenting opinion of Justice O'Connor. What does Justice O'Connor say back in Smith?
She just said that she basically just said what the majority opinion didn't want to say.
Ah, good. Okay, and what is that?
And that they're effectively reversing Sherwood and Yoder, and they're
basic test for whether religion is a valid excuse.
Exactly right. So O'Connor says, look, let's call it what it is here. They're reversing Sherbert and Yoder. They're getting rid of these cases, and they don't have the the honesty to say it outright. And O'Connor also responds to Scalia's claim. Scalia says we can't have courts singling out all these things and then making up these exemptions. We can't have society work, right? How does O'Connor propose sorting out the good claims and the bad claims? How does she think the courts can do this?
So it's just still abide by the compelling interest test and analyze it sort of like a
But isn't the problem here deciding how much of a burden there is on religion? I mean, our debate before with Samuel and Dan and others is this in fact burdening their faith? It's often a very tough question, isn't it? Right? Is this actually burdening their faith, or are they just making this up to get at the law? How are courts supposed to do this decidedly difficult question of whether a religion is actually being burdened or not, or if it's some sort of ruse to get around following the law they don't like?
Well, I mean, I think she says you look at both sides. You look at the state interest as well, and analyze the person's interest in asserting First Amendment.
Emma, how are courts equipped to decide, and this is effectively our debate before, does this law actually impose a burden on religion, or is this just, they don't like the law? What does O'Connor say to this?
She said, she said the essence of the free exercise claim is relief from a burden imposed like directly through laws.
Right. But that presupposes, how do you know if there's a burden? How are judges equipped to decide if in fact there's a burden? That's our $1 million question.
I guess they're
Are they? She says, she seems to think they are. Kara, want to take a step? How does O'Connor think courts can decide when in fact there's a burden on religion? How can a court have the competency to make that decision? What does she say?
I think she says that, like, whereas Scalia tries to hit on saying that, like, calling them like a hybrid, like calling that politics is like hybrid decisions.
Mhm.
She says that, in this case, like, then you can say it's not exactly like a hybrid decision. Like, you have to, you say in those cases, they hardly call the question the applicability.
Close. Davian, how are courts to O'Connor supposed to make these sorts of tough calls about whether in fact it's a burden, what's compelling? I mean, how are judges supposed to make this sort of decision, David? It's a good question. I mean, this is really the dividing line between the Scalia and the O'Connor opinion. This one question, which we had a very robust debate on before. You phoning a friend? I don't know. Anyone want to jump in? Well, who's to decide what's compelling interest?
Supposed to balance it.
Against what? What are you balancing against compelling interest with O'Connor's framing? What's being balanced under O'Connor's test against compelling interest? What's the wrong here? What are the Yoders and the Smiths complaining about? But what is the government doing to that? What's the key word from the Smith-Yoder test? What's the key word test that we put forward? Anyone else? You're next anyway. Yeah. Anna?
That they unduly
Burden. Burden is the magic word, right? Is there an unduly burdening of their religious beliefs? So here is the question, right? And again, we had a very robust debate. Is making a cake for a gay couple actually burdening your religion? You guys asked me this a few minutes ago. Is issuing a marriage license to a same-sex couple burdening your religion? Is using your healthcare plan to provide contraceptives to someone else, you're not using them, right? Is that burdening your religion? these are questions that people may disagree on. First, I'll get to in a second. Right? These are questions. I have to think as a matter of mainline teaching, these are not close questions, but they're questions that can be debated. O'Connor says in her concurring opinion, I'll quote it, the courts are quite capable of balancing these principles. And they can, quote, strike a sensible balance between religious liberty and state interest. So O'Connor basically says, trust us, right? We can figure this out. And Scalia's like, I don't trust you. You can't figure it out. So because I can't trust you guys to figure this out, I'm going to get the courts out of the business of granting exemptions for religious beliefs. Scalia's like, we should not be in this business, period, because we don't have the wherewithal to decide what in fact burns religion. That's not in our abilities. And then you have O'Connor saying, of course we can do it. We're judges. We can do this. Not a problem. Everyone get the disagreement between O'Connor and Scalia on this, right? Marissa?
Hearing about the first, how can you become a group of citizens that are religious and they all do the same type of thing? Like, for example, like us Christians and like Christians, I have a group of friends that I grew up with, right? And a bunch of us would certain times of year we do things together, like when our families would fast in Ramadan, we would fast at school, right? And we would still, when I was a kid, I could sit without being hydrated, I could be able to play sports like good gym class, not drink water, we would just fast the whole day, you know? But then we would, when the sun came down early and it's winter time, and I don't have any like nutrition, like because when you fast for 12 hours and anybody who's done it will tell you, like the first drop of food has to be like something that is thick and not something that's too much sugar, too much salt. Like you can really upset your body. I mean, 12 hours of eating like things you get on. So why shouldn't they have why can't schools provide some type of assistance to kids that are using the fast food or in school, like, hey, we'll have some food like at the cafeteria, 7 or 8 for the kids that are out here playing basketball. I mean, it's sort of like famously the King Large one basketball during the NBA finals. Like people in the current religion public, atmosphere, they don't obstacles. Like, why burden them? Like that's concrete to me. That's not conceptual. Like, of course, balance it. Like, kids want this.
Well, I think a better question, Marissa, would be this. What if a student fasting for Ramadan declined to participate in a gym class? Because maybe for him, he could, based on his independent body, he couldn't participate in physical.
Some days I didn't go through that.
Right. So with taking a failing grade in gym, say you miss the entire semester, it's roughly a month long, right? Good job. Right, but I think your point's well taken, right? There probably are some cases where it's very easy to say there's religion on these, but Scalia wants to be very conservative and say, we don't know what the burden is going to be. Let's get out of this business. Let's get out of this business of carving out exemptions to the laws. Okay? So Scalia, in a 5-4 decision, basically won the day here, but not for long. He did not win the day for long. And we already discussed what I'm about to say next when we did Section 5 of the 14th Amendment. Let's talk about RFRA, the Religious Freedom Restoration Act. So about 2 years after Smith, this decision was viewed as being extremely unpopular, How could it be, they said, that a religious group should not be getting accommodations? How can it be that a Native American can't uses peyote and is being punished by the state for using this sacrament, right? How could this be? So Congress passed a bill called RFRA, the Religious Freedom Restoration Act. To give you a sense of how popular this vote was, it passed almost unanimously in the House and virtually unanimously in the Senate. There were only a couple of nay votes. This was a bill proposed by Republicans and Democrats alike, signed into law by President Clinton. Such bipartisanship is unfathomable today, but this was an issue on which basically everyone agreed that Smith was bad. Smith was wrong. As I repeated more times than I can count, the Supreme Court is not the only one who gets to interpret what free speech means or free religion means, right? They don't have a monopoly on these phrases. So what did RFRA do? RFRA imposed a new standard. And RFRA said that the government cannot impose a substantial burden on free exercise. They cannot impose a substantial burden of free exercise unless they can show it was the least restrictive means, unless they can show that it was the least restrictive means of furthering a compelling governmental interest. Of furthering a compelling governmental interest. So what does that mean? Well, here comes the debate. Did RFRA merely seek to bring back Sherbert and Yoder? Religious freedom restoration to restore? Or did RFRA go beyond Sherbert and Yoder and provide additional protections of what the government cannot do? This was a hotly contested issue, and the Supreme Court in the Hobby Lobby decision split 5-4 on this point. The majority opinion by Justice Alito said that RFRA goes beyond Sherbert and Yoder. How do we know this? This language about the least restrictive means was not in Yoder. That's new. The dissent by Justice Ginsburg said, no, Sherbert and Yoder were merely restored. Okay, so what does this phrase least restrictive means mean? And I'll give you an example from a very contemporary example that's before the court now, which is the Little Sisters of the Poor case. Now, I am going to simplify it to the fact where what I'm saying is actually wrong. The facts of this case are very complicated because of something called ERISA. How many of you have ever heard of ERISA? It's this complicated statute that governs retirement plans and healthcare plans. It's so complicated, I don't want to bore you with it, but I'm going to simplify this just to give you a hypothetical. Okay? The government says, we have a compelling interest in promoting women's health and ensuring they have access to contraceptives. Okay? We are going to achieve this by the following. We're not going to make the Little Sisters pay for the contraceptives. We'll make the government pay for it. So no money out of their bank. In fact, they have to do absolutely nothing, right? What we'll do is we will contact their insurance company and we will then provide the contraceptives through their pre-existing plan. The Little Sisters have to do nothing. Okay? Those are not the facts. I'm simplifying it, but that just bear with me for argument's sake. So the question is, does this impose a substantial burden on their free exercise? The Little Sisters say yes, because they are involved in the doctrine of scandal, that they are complicit in sin. Government says no, they're not involved, and if they are involved, it's not a substantial burden, it's just a small burden. Okay. But then we have this least restrictive means test. Okay. Is using the plan of the Little Sisters the least restrictive means of getting women access to this contraceptive? Little Sisters say no. Why not? Obamacare. They say if the government really wants to get women contraceptive, make it available for free on the Obamacare exchanges. That would impose no burden on religion. Okay? So the Little Sisters say that there's a least restrictive means available to get these pills. The government counters, wait a minute. Certainly we can give this out in the Obamacare exchanges, but it's not the same. It's not seamless, right? That a woman would have to go to an additional website and register if the website's working, who knows, right? And subscribe to this plan. So they argue that it's not achieving the same sort of compelling interest. This is in large measure the debate in the Little Sisters case. Too many Obamacare cases running crazy. So this is largely the issue in the Little Sisters case, right? Is there in fact a least restrictive means that can be used to achieve the same compelling state interest? And my personal prediction is, depending what the court says here, will decide the outcome of that case. Dan?
Isn't that in essence a way to subsidize objections?
What do you mean?
If the government is picking up the tab for the objections,
yeah,
isn't that a way to almost subsidize objection rather than saying, okay, we're not going to debate this in the courts, we're not going to debate this in the religious arena, we'll just pay for it?
Yeah. What's your point?
That was my point.
Yes. Basically, because we can't legally make the Little Sisters pay for it, the government will pay for it. Right?
It's subsidizing the objection.
I don't know, subsidizing the objection, I mean, the Little Sisters aren't profiting from this. I don't even know subsidizing the
No, but
objection.
they're objecting, well, we don't want to do this. we don't want
They're basically paying for the objectors. Like that's what you mean. They're basically paying, right? No, yeah, okay. I didn't know what you quite meant, right? They're paying because they're objecting.
Right.
I thought you meant they were giving money to the objectors.
No.
Okay. Sorry, I misunderstood what you said. Okay, very good. So that's the issue in the Little Sisters case, right? Is there a least restrictive means to achieve the same governmental interest? And if the court finds that, yes, you can give this out through the Obamacare exchanges, or you can give a special contraceptive-only card, or post other methods that could be created. And in fact, at one point during the arguments, the solicitor, I was there, very close, and I was paying close attention for this class, but the Solicitor General said, well, Mr. Chief Justice, the law currently doesn't allow contraceptives to be given out on the Obamacare exchanges. And Chief Justice Roberts replied, well, that's how constitutional law works. Sometimes you have to change the law to comply with the Constitution. Now, it wasn't actually a constitutional issue. It was a RFRA issue, statutory, but the Chief made that point. So there's still a rigorous debate now. Even though Justice Scalia's opinion removed the First Amendment free exercise clause from this debate, we still have RFRA, which gives the courts the question of deciding, is there a substantial burden? Is there a least restrictive means? And is this interest compelling? And as the debates over Hobby Lobby and Little Sisters reveal, these are tough cases that are very, very divisive. I mean, I filed briefs in these cases, but I freely concede these are tough questions. They're very difficult questions. Okay, so questions on that? I discussed this earlier, but I'll come back to it. The problem, though, with RFRA wasn't on religious grounds, it was on federalism grounds. So as you remember in a case called Bernie v. City of Flores, remember this was a church in San Antonio that wanted to expand, and the city wouldn't give them a building permit. So they sued, claiming that their rights were violated under RFRA. Now you actually understand the case. The zoning law was a law of general applicability. Everyone was subject to the same zoning law. You can't build without a permit. But they argued that even though the law is generally applicable under the Constitution, with respect to the statute, RFRA, it imposed a substantial burden. And the government could accommodate this by giving them a one-time exemption. This was appealed to the Supreme Court. Supreme Court held, guess what? Congress, you don't get to decide what the Constitution means. We do, right? We said in Smith, here's what the Free Exercise Clause means, and you can't redefine it for the states. You can't tell the states under Section 5 of the 14th Amendment what the First Amendment means. That's our job. This was the court reasserting for itself the prerogative to decide what the Constitution means. However, RFRA remained valid with respect to the federal government. That is, the federal government is free to bind itself under whatever standard it wants. The federal government can impose whatever restrictions they want. So RFRA is a super statute. Effectively, every single law that Congress ever passes must comply with RFRA. Every action the federal government takes must comply with RFRA. That's why the Obamacare contraceptive mandate, which is not really in the statute, it's more of a regulation, is still subject to the Religious Freedom Restoration Act. And the courts are now engaged in this very vigorous dispute over the Little Sisters case. What complicates that case is that we're down to 8 justices, as I said before. There's a circuit split. Some circuits, or basically one circuit, has ruled the contraceptive mandate is the accommodation is void, and the rest of the circuits have held that it's valid. So in the event that the court ties 4-4, this leaves a bizarre situation where the contraceptive accommodation is legal in some places and not in others. So my best guess is that this case winds up in a re-argument for next year. I don't know that they're going to be able to find a way around this issue. So questions about RFRA? Questions about anything else? Yes.
So far we've talked about the state not being able to compel a person to do something, or let me just get to my question. So
Take your time, it's fine.
Can the state require, say, like Jehovah's Witnesses don't believe in holidays, right? So can would it be an infringement of their religious rights to require them to work when other people are off because of a holiday? Or how can the state apply a
Well,
general rule?
let me give you a good Jehovah's Witness case. Okay, I have a good one. This is actually a recent one. So part of the Jehovah's Witness belief system is no blood transfusions, right? They do not permit blood transfusions. So there was a woman, I think she was in Nebraska, might be off. I think it was from Nebraska, and she needed a liver transplant, and she was on the state Medicaid. And under the state's Medicaid proceedings, the only way they could provide a liver transplant was through a blood transfusion, so she refused to get it. In the neighboring state, I think it was Iowa, but I may be getting my states mixed up. But in the neighboring state, they pioneered a procedure that allowed a bloodless liver transfusion. I'm sorry, a bloodless liver transplant. I don't know how it works, but science, right? They found a way to give a person a liver transplant without this sort of blood transfusion. However it works, I don't know. She sued her state saying, your Medicaid policy is basically going to kill me, right? Unless she can afford it herself, but unless the state Medicaid pays for me to go across state lines to this other state and get this proceeding, I'm going to die. The state did not have a RFRA. And citing in Point Division versus Smith, they said, look, this Medicaid law is a law of general applicability. It was not designed to single out Jehovah's Witness. It simply says we don't pay for proceedings outside the state. I mean, that's generally a fairly reasonable policy. So as a result, she lost, right? The state ultimately enacted a RFRA, which would have provided the Smith, the pre-Smith Yoder test, and said, look, even if this law is general, it's imposing a substantial burden on my religion. I'm going to die. Look, if you just pay for this one proceeding, it's not going to screw up your entire scheme. Make an exception. So this actually went through the courts, and by the time it went through the courts, she finally got a victory. And they said, you know what? Under this Religious Freedom Restoration Act, we can give you this accommodation and go to the proceeding. The problem was, by the time all this litigation transpired, she was no longer a candidate for the transplant. Right. So this is what RFRAs do. Unfortunately, these laws get a very bad reputation when people don't know what they're talking about. And this is the point of the article I asked you to read last. This is the sort of reasons why RFRAs exist. They're not licenses for discrimination. They're not. The way it works is like this. A group can say, I don't want to do business with this person because he's gay or black or whatever else, and that's my religion. Okay. Person gets sued for employment discrimination. They can then raise RFRA as a defense, saying that, look, my religious beliefs don't allow me to deal with blacks or gays, whatever happens to be. Those cases have never succeeded. They haven't. Because the state has a pretty compelling interest in eradicating discrimination. Okay? The cake cases, which you both reference, are actually not religion cases or speech cases. People don't actually understand that. The argument is you can't be engaging in compelled speech. The actually act of making a cake or a floral display is an act of speech. And the speech doctrine is pretty darn rigorous. Close question whether a DJ is speech. I was debating with a friend recently. But these cases are actually not religious freedom. They're actually speech cases. The RFRA claims go nowhere. So these laws, which are often criticized, are off the mark. They're not licensed to discriminate. It merely allows someone to raise a defense, which won't succeed. Right? You don't have a compelling interest to exclude a gay person from your restaurant because you don't like them. Those cases will lose immediately. Indeed, I don't even think under RFRA the cake cases work. Those cases are all brought as free speech cases, although some of them may actually have RFRA connotations. Okay, so with this topic, be very careful and try and read stuff closely. There's just this knee-jerk reaction to simply say that everything's evil, and there are benefits for RFRA that, like the kidney case I mentioned a moment ago, the liver case, that will go away when these statutes are repealed, and I fully expect them to be repealed in our lifetimes. Yeah.
So can you repeat what's the impact of Bernie? States have to.
Bernie v. Flores said RFRA cannot apply to the states. It only applies to the federal government.
So that way the states have to.
But not all of them did. Only about 20, I forgot the number, it's in the article, but 20-something did. Many did not. And I think states will soon start repealing the RFRAs because of the sorts of arguments that people bandy about. Questions? Questions on anything? Thank you all very much for a wonderful semester. I appreciate it. Thank you very much. Thank you. Thank you. I'll see you all in about 2 weeks.